Case law, statute law, European Union law. These are all well-known sources of law. But there is another, often overlooked, source of law. Custom. To learn more about this, we're travelling to the village of Wraysbury in southern England to learn about the case of Wyld and Silver. Although very rare, a practice amongst people local to a particular area can become law if it can be shown that the practice has existed within that locality for a significant period of time, or since time immemorial, which basically means since the beginning of legal memory, 1189 AD. In 1958, a Mr. Albert Edward Silver purchased some land here. It was one of several parcels of land in this area. As outlined in the judgment, Plot 277 was owned by Wraysbury Parish Council for the benefit of the local people, consisting of a children's play area and cricket pitches, and known locally as the Village Green. Plot 278 was owned by a local tennis club and is covered by tennis courts, then as well as now. Mr. Silver purchased Plot 279. Although the exact location of Plot 279 is hard to pinpoint, it is likely to be either here or here. Mr. Silver's idea was to transform this land into a residential area. Planning permission had been obtained for 5 bungalows and garages, and he had begun digging up the soil in order to commence the building works. Regardless of the precise location of Plot 279, a Mr. Robert Stoddart Balgany Wyld was not happy about Mr. Silver's intentions, and neither were many of the inhabitants of Wraysbury. Mr. Silver called a town meeting, presumably to clear the air and win over the hearts and minds of the disgruntled Wraysburyans, but he faced a vote of 301 to 11 against his continuance of the building works. In spite of these objections, Mr. Silver continued. At trial, the legal argument was that the residents of Wraysbury had, by a local custom, an ancient right to hold a fair or wake on the Friday in Whitsun week, Whitsun being a religious date that falls 49 days after Easter, on the plot of land purchased by Mr. Silver. As Lord Denning explained in his judgment, the fair was a gathering of buyers and sellers. The wake was the merrymaking which went with it. This right had not been exercised in over 150 years, and there was no living memory of it ever having occurred. Its existence had, however, been confirmed in a private Act of Parliament dating back to 1799, which stated that the inhabitants of Wraysbury shall for ever hereafter have the same right to hold such fair or wake annually. In Lord Denning's opinion, this was not only evidence that the right existed, but also merged the customary right with an Act of Parliament, thus granting the inhabitants a statutory right, not only a customary one. In any case, Lord Denning held that this was at the very least evidence that the right existed, and even though the right had not been exercised within living memory, it was nevertheless a right that the inhabitants still had. Even though Mr. Silver had obtained planning permission from the council, who knew of no such right, and even though the title deeds to the plots of land did not inform him of such a right at the time of purchasing, this did not preclude the existence of the right. Enforcement of this right was said to be harsh on the defendant. However, Lord Denning's words were, "So be it. It is one of the risks which he must take." Thus, the court granted an injunction against Mr. Silver, preventing him from building on the land or doing any other such act or thing as would prevent or interfere with the holding of the wake or fair thereon. Not only was he prevented from building on the land, what must have been a real stinger for Mr. Silver was that he was also ordered to remove all such things placed on the plot by him and to fill up all such excavations as he had made on it, so that the fair, which hadn't been held in at least 150 years, could take place. Now it's time for Rory Mayo's Top Tips.
Rory Mayo's Top Tips.
Although a custom should be said to have existed since time immemorial, or since the beginning of legal memory, defined in the Statute of Westminster 1275 as 1189 AD, a claimant does not necessarily have to prove that it existed this far back in time. As Viscount Worm said in Woolstanton Limited, an Attorney General of Duchy of Lancaster Repellents v Newcastle Underline Corporation Respondents 1940. In the case of an alleged custom, it is sufficient to prove facts from which it may be presumed that the custom existed at that remote date, and this presumption should in general be raised by evidence showing continuous user as of right going as far back as living testimony can go.